First case is case number 23-2128, Rosa Bonilla Granados versus Bells et al. Appellant's counsel? Appellant's counsel, when you're ready.
May it please the court. That was a little loud. Randy Porche on behalf of the claimant and the appellant, Ms. Rosa Bonilla. I'd like to reserve 6 minutes for rebuttal. To be as clear as I can possibly be, nothing in this appeal seeks to vindicate microaggressions or ordinary friction in the workplace. Instead, this appeal questions, can we establish, and the answer is yes, objective standards by which the judge can determine a claimant's justifiable refusal of even physically suitable employment. We're not talking about abstract slights, we are talking about objective standards. Now, I know that you know the facts and have read the briefs, but if I can give the briefest overview, Rosa Bonilla has a 6th grade education. She's in her early 50s, and for her entire working adult life, she has had one employer. And for that employer, she used her manual strength to move and package clothing. And in 2019, March of 2019, she began having shoulder problems, which she reported to her supervisor, and a report was made of that. For the next, I'm gonna say, year and a half, she did not rush into litigation or stamp her feet. Instead, she used what she had, which was meek reminders, steady reminders, and some in writing saying, can I please get assistance for this shoulder injury? And then in February of 2021, a doctor recommended shoulder surgery, and the shoulder injury was denied, the surgery was denied, and she was told in March of 2021 to gather her things and leave the workplace of 14 years. What happened thereafter was, for everyone in this room, it looks like litigation. But what happened is the employer did not offer her work, they did not give her wages, they did not give her medical benefits. They raised some 25 defenses, erecting defenses of crushing confidence against this individual who only had her word to stand against her employer.
So, counsel, is your argument in the nature of if an employer litigates a case too hard for too long, but then loses, the claimant wins, but then a suitable job is offered, that the claimant is then free to deny it because the litigation, because of the characteristics of the litigation?
Quite the contrary. That is not my argument. That is the context of this case, but I wanted to raise one other factor. The employer had an answer for everything. They had multiple defenses, but then they went after Rosa, the person, and her integrity, and said she was committing fraud and indicating that she had been injured in 2019. They brought 6 employer representatives to take the stand and testify that the facts were not as she represented, under the flag of a fraud prosecution.
So is the principle in your case that if the employer litigates the case hard and alleges fraud, that then a suitable job can't thereafter be offered?
The answer to that is, I am not going to say, can I say yes and no? No, those facts alone would not do it. But here, the judge of compensation.
Isn't this a 44205 type thing?
So, Your Honor, I think you could argue that, but I am not asking to, and I think what they're saying is read a remedy out of the law, which is the individual's right to say, I am justified. And please look at it from an objective standpoint,
Well,
considering
you
that.
say in your brief, you use the terminology hostile work environment as justification for her not going back to work. I mean, we're merging, basically, are we not? Or how do you explain harmonizing 44205 with the argument you're asserting?
Certainly. So what I would suggest is we don't read a remedy out of the statute. I probably need to go a little further. The issue is the judge of compensation claims found that the employer had made misrepresentations, was untruthful, and had engaged in an implicit conspiracy to deny this claim. So the question is, is it justifiable for her to then say this relationship is irretrievably broken? And that is the question. So do we have an objective standard that we can rely upon? So if
Well,
I
let me get further
Sure.
clarification from you. The way I read your argument, at least the way the issue is phrased, issue 1, and then the verbiage in your brief, you're raising an as-applied constitutional challenge. That's the way I read it. And if so, what's the applicable constitutional standard of review?
And I certainly hope, Your Honor, that means I failed. I suggested that this is not a constitutional challenge, but the constitutional liberties and rights to one's body, to one's integrity, the right to be left alone from harmful conduct should undergird and inform the word justifiable. And I asked you to think of one. I was trying to think of a metaphor, and that's probably not my strong suit. So I was thinking, take these facts and just flip the script. The employer suspects for 3 years that Rosa Bonilla is skimming $2 from the cash bin. They can't prove it, but they ask her. She says, no, it was Pedro Limas. Definitely wasn't me. And then after 3 years, they catch her on video stealing the $2. It's only $2 from the cash bin. And they say, we can't have you work anymore. And the question would be, is that justifiable? And the answer is unquestionably so, because
Would you agree that the justifiable, we're looking at that as to whether the JCC abused his discretion in determining it was justifiable?
well, because the judge said it is in most particular her reason, and the least educated and the least sophisticated person in this whole case was asked, do you think you could do this one-armed left-hand job if it weren't for the trust issues? And she said yes, but then she asked a question. She said, how do I go back like that when I don't have the trust? And that was never answered.
So is trust the objective standard? I'm searching, my first two questions were searching for an objective standard.
Oh,
that
sure.
we're talking about. What is the objective standard?
Absolutely.
That when we see it and when the JCC sees it,
Absolutely.
that they can act on it.
So first we take the perspective of the injured worker from the lens of a reasonably objective person. That is the standard in every area of the law. Every area of the law has an escape for a person who is being subjected to misconduct. So if you're not looking at it from the claimant's perspective and you're only looking at it from the employer's perspective, you've taken the employee's justification or justifiable, you've written it out of the statute because the employer's always reasonable. And in this case, you had an employer that had a policy, which is we're always right because we're never wrong. And the judge said, well, it's wrong to focus on their policy because that's completely irrelevant. So we had a tautology that was feeding itself, and Rosa's perspective was never seen. When it comes to something like misconduct, I would say that there would have to be something in the nature of objective misconduct. The kind of conduct that traditionally we don't accept from others, and being untruthful, engaging in an implicit conspiracy, and I'm certain that the employer has an answer for everything. But the individual who was subjected to this experienced that, and it happened. So when she said, this relationship is broken, that is a healthy response to what happened to her. And the judge said that is completely irrelevant. And so she got caught in this vortex where her perspective was never considered. So we
the
have
objective standard is if there's objective misconduct in litigating a workers' comp case, then the claimant is entitled to refuse a suitable job.
I would not say that either. I would say the objective standard is an objective person. What is your reason? Is there objective misconduct? Then the judge has to consider that in determining what does justifiable mean. Is it a good reason to say this relationship is not a healthy thing for me? Is it reasonable?
Misconduct matching willful, such as unemployment? I mean, how are you defining misconduct?
Well, that would be a good question. I think good cause is the standard that you use in employment, and it is admittedly a standard, and there is case law on that, but good cause would be a reasonable standard. Now, I point out in unemployment, the employee has to prove good cause attributable to their employer. Now, we have cases on the books where somebody lives 132 miles away from the employment, and we look at it. Well, let's look at the objective person. Where do they live? Yes, they actually live there. Is it reasonable, justifiable for them to transgress those miles for an ordinary, and Judge Osterhaus, you said this, is it ordinary, self-imposed, manageable? And to get to those questions, and you didn't just say that, Judge Osterhaus, but in the Employee Bridge versus Rodriguez, you set out that standard. And that is a fair standard, and it's the right standard. You would not consider where the judge lives relative to the warehouse. You consider where the person lives to the warehouse, and you put out objective standards. We should not be afraid of objective standards, because the lack of objective standards lead us to where we are here today, where the employer says it doesn't matter. It is irrelevant to any consideration as to whether there is good cause to separate oneself and walk away from the relationship. I'm way into my rebuttal.
Thank you, counsel.
Thank you very much.
May it please the court. My name is Bill Rogner, and along with Daniel DeMay, I represent Bells and Sedgwick in this case. So, Mr. Porche's brief is what labels the employer's litigation behavior as misconduct. He uses the word 72 times in his briefs, but it's not found in either order. It's not found in the 3,000-page appellate record. And then they make this really emotional argument in the brief, citing Blackstone's commentaries and the Declaration of Rights in the Florida Constitution, and then they combine that with microaggressions and chattel-like treatment and fractured relationship and mistreatment and despair and all this stuff. It's completely a function of the appellate brief, because this claimant made 4 arguments below. They're addressed in the closing argument starting at page 604 of the trial transcript. 4 arguments, okay? 1, she had been effectively terminated when they sent her home during the course of the litigation. So this wasn't a real job offer. Number 2, she believed she would be forced to work outside her restrictions. That was a big focus of their argument. 3, she feared she'd be hurt again. That's the third one that they argued. And then 4, they did not believe the job offer was real. They thought it was fake or a litigation tactic. That's what they argued at the trial. And they seize on this phrase that Judge Weiss uses earlier in the order, where he says, look, what happened when you tried this case in front of Judge Grindle is irrelevant to what we're deciding today, because they're 2 different issues. Remember, the first case, the first trial, was about compensability, causation, restrictions. And Judge Osterhaus, we are allowed to raise any defense that's available to us under Chapter 440, whether it's statute of limitations or misrep or anything else. So yes, they defended that case, and here's what happened. Judge Grindle rejected the testimony of the employer witnesses. He said two of them, I find less credible than the claimant, and I accept the claimant's testimony. Okay, that was Mr. Lemus and Mr. Rivera, okay?
So is your argument that you don't find so much of a problem with the idea of his case, but there was no misconduct found here? If there would have been a finding of misconduct, then this case has legs.
I would have no problem if the evidence convinced Judge Weiss that, for example, this job offer was a litigation tactic and a sham. The judge is free to find that. One of the things they talk about in their brief is, if we just focus on the statutory language, it would allow me to, for example, offer a bank president a roofer job and say, well, you gotta do it. Well, that's not true, because the statute itself says it must be suitable to the capacity thereof of the injured worker. I could no more offer the bank president a roofer job than I could offer a roofer a bank president job, and it's right there in the statute, and the judge can consider that. And Judge Osterhaus in Employbridge, there was no majority opinion in that case, as you know. We have one concurring opinion written by Judge Thomas, the other one, and then we have your concurring opinion, and what you said was, I don't think we should be creating court-made tests, because the statute gives us what we need. And yes, the standard when we're reviewing these decisions is factually, is it supported by CSE? And then on the
But
judge's...
it's solely about the capacity issue, whether the job matches the person, or can there be something that went
No.
before that is so damaging to that relationship
Yes.
that it can be justifiable to say, no, we're done.
I think that if her supervisor had sexually harassed her, for example. I mean, these are facts that aren't present here. And look, keep in mind that Judge Weiss analyzed exactly the arguments that they presented to him, all of them. After he says what happened before is totally irrelevant as to what's going on now, he then spends 2 pages of the order analyzing the arguments that they made, and then he does what he's permitted to do. He's the fact finder. He's permitted to accept the testimony of the employer witnesses, which he found more credible, and to reject her testimony. He found that this job offer was legitimate, so that there are 2 jobs that are available to her. Both they have the job descriptions, permanent job descriptions are in the record. They're both advertised jobs. They're jobs that have people working in them right now that maybe weren't hard on the job. They're legitimate jobs. He believed Mr. Lemus, the supervisor, when he said, I never treated her badly. I never yelled at her. We want her to come back.
You almost answered it, but would you agree that it's an abuse of discretion standard then?
Yes.
That we use for justifiable? So if, and I'm not saying that happened here, but if a fact finder has discretion and they refuse to use that discretion, is that not an abuse of discretion? And then second question, did that happen here?
Okay, yes to the first and no it didn't. And the reason I'm saying it didn't, and I think the order itself is clear, and the other thing the other reason I say this is because the judge, he granted 2 hours of closing arguments. He actually set it for an hour, and he ended up giving the lawyers 2 hours to argue about this stuff. And he did consider all of it. He considered each of the reasons in the order, and he rejected those reasons. And the statute says it has to be in the opinion of the JCC not justifiable. The judge made a specific finding that I do not believe it is justifiable. It is clearly Judge Weiss's opinion that the refusal was not justifiable. It is an abuse of discretion standard. But what the test that Mr. Porcher tried to propose, and what he also posits in his brief, it's almost like a feelings test. You know, I don't like my boss. My boss was mean to me. They were mean to me when they litigated this case, and therefore I don't have to go back.
So when the judge finds in the order, claimant's focus on what occurred prior to May 2022 as completely irrelevant, you would read that as he's exercising his discretion.
You know, what I think he meant, I think it's an unfortunate turn of phrase. You know, I often read these orders when I'm asked to defend them, And I wish I could have been involved in the order writing. I think it's an unfortunate turn of phrase. And what he's actually saying is that it's not binding or controlling on what we're doing here today. And the reason I believe that, Judge, is because immediately after he uses that phrase, which they put in the brief almost as much as they put in the word misconduct, is we get 2 pages of these are the reasons and I'm rejecting them and here's why. And so he did properly exercise his discretion. He considered her arguments. But what he was not willing to do is say, okay, you never have to go back because the way that this first litigation went for you. Because you did not like it, they said you committed a misrepresentation, and therefore you don't have to go back. Does this give the injured worker the veto power over a job offer? As long as you can establish objectively that somebody was mean to them. So I have deposed over 1,000 injured workers. A very high percentage don't like their boss. A very high percentage don't like their job. That's part of employment in the world. And so it can't be that standard that she just gets to say no because all she said at the trial, this is all she said at the trial. Why won't you go back? They have treated me bad, very bad. Okay? She says, Mr. Lemus yelled at me. Mr. Lemus said at trial, I never did that. Judge believed Mr. Lemus. Mr. Lemus made me work outside my restrictions. He said, no, I didn't, and no, we won't.
Isn't this a 44205?
I think there are remedies that are not here, right? Not in the 444 on 44205, employment law. There's lots of things out there that provide people with remedies for the behaviors that they allege, and it's alleged only.
And we're saying here, 15, current 6, not 440 as a whole.
Yes, 440.15.6 is the answer here,
Yeah.
but 442.05 is circuit court. What I'm saying is, if you want to file a 205 claim, go file your 205 claim, right? I am asking you to simply apply the plain language of the statute, which says, and this statute was written, and I do agree with Judge Thomas's comment in his concurring opinion in Employer Bridge when he said, look, this statute, 440.15.6, it's a hammer. It's a bludgeon, because it says you do not get paid if you refuse to work. And he read that as a legislative expression of intent that we want people to go back to work. 440.05015, the legislative declaration of intent says it is the intent of the legislature that the workers' compensation laws be interpreted to assure the return to gainful employment of the injured worker at a reasonable cost to the employer. Okay? Now, they also make a big deal in their brief about the fact that when they were litigating, they didn't offer a job, and they only offered her a job after the first trial. Okay? Well, it's not sheltered. It can't be a litigation tactic because they offered it to her right after the first trial and 9 months before they filed for permanent tow. So it wasn't a reaction to the PTD fund. But there's a very good reason for it. Bells has a very well-established workers' comp return to work program. And the dispute at trial 1 was whether this was a workers' compensation injury or not. So they say, and she was told to go home and not come back until she had this fitness for duty report. Well, there's a reason for that. In non-comp injuries, the employer can't see the medical records. You can't talk to the doctor. You don't get to direct medical care. In order for them to come back, they have to go get their own care. And when you get it, and you're cleared to work, bring us this form. Trial 1 happens. Orders entered. It says, no, this is comp. The first claim's denied. 2019 is out. The other 2 claims, you're good. One of them you're 0%, the other one you're not, but here's what's covered, here's what's not, and here are your restrictions. And it's workers' comp. So 1 week after the trial, because that's the policy of Bells, they offered her a job in conformance with that return to work program for injured workers. And here's what happens most of the time. I litigate hundreds of these things, right? The job offer's made. Claimant says, they're lying, it's not real, it's bad faith, they're gonna make me work outside my restrictions. Claimant goes and tries, and here's what happens. Sometimes it works out. Claimant's back at work, everybody's happy, legislative intent has been fulfilled, right? Sometimes they go back and the job offer was a sham, or the job didn't exist, or it doesn't exist anymore, or they go back and then they get laid off. You can go file for your permanent total then. The problem here, the fundamental problem, is that they offered her a job virtually monthly for a long time, up until this trial. And the testimony was, those jobs are available right now. Problem was, through trial counsel, they just kept saying, no, this is a bad faith offer. No, this is a bad faith offer. This isn't real. And the normal course is to try it, right? Try the job, see if it works out. That's what the legislature wants. That's why 440.15.6 is there. And as far as her being stuck for life now, because that's one of the arguments they make, that we just get to hold this over her head for the rest of her life and she can never get paid. No, that's not true, because you've told us in your cases that a denial of PTD benefits is not res judicata as to future claims for PTD benefits. You can file for PTD from the day the order comes out that says you lose. You can file from that day forward if you want, and you're free to do that. And these cases sometimes do get tried twice or three times on that issue. And the first time the claimant loses, then the claimant goes and tries the job or does a job search if the job search was lacking, and then they come back and they try it again. She's free to do that. She's not precluded. But what she is precluded from doing is vetoing the job offer of the employer when the judge finds that it's both legitimate and that her refusal reasons are not justifiable. So, Your Honors, we want you to apply the plain language.
And your claim is that it might have been justifiable if the harm was serious enough, a sexual assault or whatever.
Sure, it could be.
But here we're talking something far short of whatever that line, that threshold is.
I certainly think so, Judge. So we want you to apply the plain language of the statute, which, you know, the JCC found that the refusal was not justifiable, and we think the order should be affirmed on that basis. Thank you.
So we've heard much about the employer's policy. It is not in the record. It is invoked by the employer when convenient. Today we heard for the first time the reason they do it is because they do not have access to the medical records, which can't be true here. They had access to the medical records. But one thing they don't have an answer to is several things, is let's go to May 24th. Ms. Bonilla has just endured what for a person, not a lawyer, for a person is a devastating series of events where the people she once trusted has betrayed her. She gets a letter in the mail from their counsel saying, we have light duty available for you. 3 days later, before the time to even respond to the letter, they ask the judge, vacate that order, take away any allusion to our bad findings, and enter an order saying that her work injury is not related so that we can revert back to our policy and deliver the intent that we wanted in the first place. So if we put ourselves in a reasonable person's situation, heck, I'll even go to their policy. What does their policy say about that? Well, their policy is essentially we're always right because we're never wrong. But what would that person think reasonably is going on? What did they do? And when I talked about flipping the script, you know, when I talked about flipping the script, she gets caught stealing $2. They kind of suspected it. If she wrote 82 certified letters to the employer and said, take me back, I've changed my ways, is it justifiable for the employer to say, no, stealing is wrong? And the judge did find it's untruthful. And I think the biggest fallacy here is the suggestion that the judge considered that. The employer objected and my computer came up with 103 times at trial, some 50 times, let's say. 50 times, relevance, 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 relevance. And what did they object to? Their motion for rehearing that the real person in real time, they objected. This can't completely be relevant.
Was there any effort made, I looked at the chronology of the job offer letters and responses, and they were pretty quick, in response. Was there ever an effort made, I didn't see a letter that said, the claimant feels like this is going to be a hostile work environment based on the history of litigation? Delivering that message to the employer to see, are there other options, perhaps location, place me at a different location. What individuals am I gonna be working for? Some form of notice and effort to the employer to communicate this, I'm uncomfortable coming back, is there anything that can be done? At least, if we're looking at unique circumstances, we've got good faith effort on both parties, from both parties to communicate.
So the answer to that question is there was a stop it motion, which was they keep sending these certified letters. They don't need to do that. It causes her stress. Now, I interpret your question, and I think it's a valid question if the relationship is not irretrievably broken.
But she's represented by counsel.
She's I think it was made very,
Can happily communicate on her behalf.
I think it was.
So was there any communication to put on notice the employer, she's resisting either equally or in large part because of she feels it's a hostile work environment, as opposed to I don't think the job is within the restrictions, to see that there was an option for location or otherwise.
I think so, Your Honor. I did not write the letters, but I think the media letters were responsive to perhaps how you would respond if someone stole from you or testified untruthfully. It's, essentially this relationship is irretrievably broken, and the healthy course is to move on. But we're led to.
You can have leave to briefly conclude. You're into you're over your time.
Thank you very much, Your Honors. This is an important issue, and I think it is time, and I think everyone in this room, except the employer sitting here, would benefit from an objective standard that is to be employed in every case. I think the concurrences in Employ Bridge versus Rodriguez come very close to doing that, and it should be applied in every case such that somebody won't say, well, whatever happened before is completely irrelevant, and that relevance loops over and over to where the natural person is written out of the law. I thank you very much, and I ask for reversal using the correct standards based on the word justifiable.
Thank you very much.